Welcome, everyone. My name's Cary Coglianese. I'm the director of the Penn Program on Regulation and a member of the faculty at the University of Pennsylvania's Law School. I'm delighted to welcome you all to today's webinar on Trump's AI policy framework. Before we get underway, I thought I'd offer some opening remarks. And in fact, this morning, as I was thinking about what I might say, I received, as I do every morning, a number of news alerts. One caught my eye from Axios, and there was a piece by Jim Vandehey and Mike Allen, who noted something that I thought could be helpful for framing out and introducing the subject today. They note that with AI technology, quote, we've unleashed something powerful, something growing exponentially. They say further, think of this as the dawn of a new atomic age. It's unclear, they write, where this ends and the good or bad that might be unleashed along the way, but this is their view, it's increasingly clear that absent better leadership, collaboration, and understanding, American society, workers, academic institutions, and government aren't remotely ready for what's unfolding. That's their view, and I think it is something I'm sharing because we're gathered here today for a conversation in that spirit of collaboration and search for understanding to discuss what Congress should be doing, if anything, right now by way of adopting AI legislation. The impetus for our conversation is the National Policy Framework for AI that the Trump administration issued last month. But it's also a conversation prompted by other policy levels at all levels of government and even around the world. The EU adopted its AI Act in 2024. State legislatures here in the US have been adopting bills, large and small, dealing with AI. Colorado in 2024, California and New York in 2025. The National Conference of State Legislatures last year reported that at least 38 states have passed more than 100 bills touching in some way on AI. And when President Trump took office last year, he issued an executive order on removing barriers to American leadership on AI. Later, in July of 2025, the administration issued its AI action plan. And at the end of last year, the president signed Executive Order 14365, aimed at ensuring a national policy framework for AI, reflecting a particular concern about the growing patchwork of state laws in the United States dealing with AI, and a desire on the administration's part for a more uniform AI policy approach, generally one that might be a light touch. But keep in mind that an executive order is not the same as federal legislation. It can't preempt state laws. That was tried in the middle of last year, but a provision to insert a preemption clause in the big, beautiful bill, as the Trump administration referred to it, failed resoundingly, in fact, in the face of opposition from state governors and child advocates and others. And so last month's framework, March of 2026, emerged as a result. It's just a framework. It's not a law or regulation, not even a fully formed piece of legislation. It's just a 3-page document with 7 main elements. It's put forward to spur discussion about AI legislation, like the one we're having today, and further drafting and legislative development. I would note that Senator Marsha Blackburn, for example, has a 291-page piece of draft legislation yet to be introduced, but also for discussion. For those who are not familiar with Trump's national AI policy framework and its 7 major elements, let me just briefly mention them, and we can talk more about some of these in our discussion. We may not touch on all of them in the time that we have. The last one listed in the policy framework is on preemption, and it reflects a desire by the administration to make sure that federal legislation is adopted that can preempt and create a uniformity across the country on AI. But the other 6 elements in order deal with 1, child safety, 2, the impact of AI on communities, such as through data centers and increased energy costs. 3, intellectual property issues raised by artificial intelligence. 4, censorship and free speech issues. 5, removing barriers to AI innovation. And 6, protecting jobs and workers in a transition to an AI-enabled world. So our goal in the next 75 minutes or so is to use these 7 elements, the national policy framework as a whole, as a springboard to what I expect will be an illuminating and wide-ranging conversation among 4 of the leading experts on AI issues from the University of Pennsylvania. Our aim is to talk about what any federal legislation, if it's to be adopted on AI, ought to look like, what issues should it deal with, and more broadly, what is some of the leading research about AI and its impacts on society, or AI and governance, bring to the table to inform deliberations over AI legislation. Now, before we begin, I do want to thank our co-host, the Penn Washington program. This is the university's hub in Washington, D.C. that aims to bring educational content to the policymaking community there. In addition to the institutional sponsorship by the Penn Program on Regulation and the Penn Washington program, we also have co-sponsors from the Center for Technology, Innovation, and Competition, Penn School of Social Policy and Practice, and the Wharton Accountable AI Lab. I want to thank them very much. We'll have around, 45, 50 minutes maybe of conversation among our panel members before we turn to questions from you, the audience. You can submit your questions at any time during the conversation using the Q&A function on Zoom. I'll be monitoring those, and we'll try to get to as many of those questions as time allows. And now I'd like to invite our panel members to join us, and I will introduce them to you. Ioana Marinescu is an associate professor at Penn School of Social Policy and Practice, with secondary appointments in the economics department at Penn and the Wharton School. And she's a research associate at the National Bureau of Economic Research. A labor economist, Ioana studies, among other things, how technological innovations such as AI affect wages, employment, and inequality. Next, Jennifer Rothman is the Nicholas Gallicchio Professor of Law here at Penn, with a secondary appointment at the Annenberg School of Communication. She's a globally recognized scholar in the fields of intellectual property, privacy, entertainment and media law, and the leading expert in the country on the right of publicity and personality rights. In fact, her website, Rothman's Road to the Right of Publicity, is a key resource for understanding the laws that protect against unauthorized uses of a person's identity, including by AI-generated technology. Kevin Werbach is a professor and currently the chair of the Department of Legal Studies and Business Ethics at the Wharton School, where he directs both the Wharton Accountable AI Lab and the Wharton Blockchain and Digital Asset Project. He spent the past 3 decades exploring the major trends that we're seeing in emerging technologies, including the legal and ethical aspects of artificial intelligence. And he's the host of the terrific podcast called The Road to Accountable AI. And finally, our colleague Christopher Yu is the Imisogi Professor in Law and Technology, as well as Professor of Communication and Professor of Computer and Information Science here at Penn. He's also the founding director of the Center for Technology, Innovation, and Competition, as well as the co-director of the Penn Center on Media, Technology, and Democracy. He's one of the world's leading authorities in law and technology, and a frequently cited scholar in regulatory law and intellectual property law and antitrust issues. With all of that underway, and my colleagues here now to join us, let me start with the one facet of AI that might be closest to home for most anyone attending this webinar today, and that is AI's potential for changing the work that we do and its impact on the job outlook in the economy. So I want to turn to you, Ioana, first. If you could just maybe share with us what you've been finding from your economics research and what you see as the implications of what we know about AI technology and its implications for the workforce might mean for federal legislation. Ioana?
Hi, everybody. So glad to be here. So, when you think about how AI might affect the labor market, first of all, I want to say that there's a lot of uncertainty, but I've been thinking about that and researching it. And the way I like to think about it is what kinds of tasks and jobs might AI replace? And it turns out, if you look at the data, you see the AI replacement potential. There are in the indices that others have calculated for that, and you can look at that versus whether jobs were done remotely during COVID. And why COVID? Because that's the moment where we were maximally trying to do everything remotely, and there's a very strong positive correlation. Essentially, the more a job was done remotely during COVID, the more it's a job that has the potential to be replaced by AI. So I come to this conclusion that really the big difference is what I call the intelligence jobs, which is these remote feasible jobs that you could do at a computer as a disembodied spirit out in the internet, versus the in-person jobs or physical jobs that you have to be there in person to do. And this includes things like lawyering in court and teaching in person, right? So it's not necessarily something where you have to literally press matter with your hands, but you have to be there as an embodied flesh and blood human being. And so the point is, AI can replace all of these, likely replace in the end, most of these intelligence tasks. And so people will, we argue, reallocate to these in-person or physical jobs. Doesn't mean they won't work with AI, but there has to be an important in-person component. And why? Because you could say, hey, wait a second, we could replace people with robots. But let me tell you something. The cost of robotics is still very high and coming down very slowly. So if I'm a business person, I'm looking at the huge power and low cost of AI and at the still pretty high cost and slowly declining cost of robotics. I want to replace the people, if I can, in the intelligence tasks. So where does that leave us in terms of wages? Well, our analysis shows that the impact on wages in the economy is ambiguous. We don't know what's going to happen. In the beginning of this transformation, wages likely would go up, but they could decline eventually. And it depends on a number of complex parameters. So it's very uncertain, what will happen to the labor market. Now, what do we do about policy? And that speaks to the AI framework that we're here to talk about today. In section 6, they talk about training. And they say, like, we should train people for AI training. And here I want to say, like, I think this should be something bigger. AI training is useful, but what we really need to do is to train people in whatever it takes to adapt to the AI economy. And that might include training them for these in-person jobs, for example, in healthcare, rather than only training them for AI. So I think it's really important to think about how we train people in a flexible way so that they can adapt to the new economy and not just only strictly training them in AI. And that's why I've proposed in one of my papers the creation of a policy called AI adjustment insurance, which would provide people who lose their jobs due to AI with additional training, longer unemployment benefits, and wage insurance to cushion them in case they suffer short-run wage losses. So, that's kind of one element that I want to put out there. And I'm also supportive of the proposal in the AI framework to track things. They say I think that should be a bipartisan interest. Let's track things. Let's get data to track what's happening in the labor market. And then I think also training is useful, but we shouldn't stop at AI training, but rather provide people with opportunities to train to adapt to the new AI world, whatever it takes, in particular train for in-person occupations.
That's great for a picture of the labor market overall. Jennifer, if I could turn to you and think of if you have comments about particularly the workforce in the entertainment sector. We know that actors, writers, producers have taken a particular interest in how AI might affect them. Can you talk about that and what that might mean for federal legislation?
Absolutely. Although I'll start by saying I was listening to Ioana and I was thinking that we should only be doing this conversation in person because otherwise we'll be irreplaceable. So anyway, I spent some of my time thinking that. I also think it's really important to contextualize this discussion, and I think the entertainment industry is a good way of thinking about this, is that in this moment where we're talking so much about AI as a disruptor and a game changer, and it is, AI has been around for a long time, and so its scale, cost, and accessibility have shifted. But the film industry has been using AI, for example, in visual effects for decades, and the ability to replicate actors in performances has been very good for at least the last 10 to 20 years. It's cheaper and easier now, but it's actually been very good for some time. So I just think it's important to put that perspective on, and I'll add another perspective, which is a lot of the discussion about AI is about an existential threat to the entertainment industry and significant challenges for the entertainment industry. And here I think we also need a little bit of a reality check, which is that the entertainment industry is facing a host of headwinds that are unrelated to AI. So I am going to talk about AI because that's why we're all here, but I just want to flag quickly a few other things that are going on in the industry so that you understand sort of the context of some of the AI negotiations. So one of those is, people know a lot of these, the collapse of the theatrical model, the shift away from the cable market, which funded a lot of smaller stations and channels, the rise of streaming services who like AI a lot and are also invested in AI, but streaming services who don't necessarily have their profits tied to particular products, who also don't necessarily need to make any money off their entertainment offerings. Think Apple, think Amazon. And then, of course, a shift to short form amateur content. And this is another place where we might see some AI pressure, but not necessarily the way we think about it in the labor markets and the entertainment business, which is that a lot of content from influencers and short form content could be easily generated by AI. And we already have AI generated social influencers. So that's a place where AI is coming in. But I think that the conversation about AI, you need to sort of open the aperture a little bit to those contexts. And the strikes from 3 years ago, which shut down the film industry for a long time, were covered in the press as largely about AI, but were also very much about all these other things. The most recent negotiations, because all the contracts are up for renegotiations, have not centered actually on AI and have sort of largely stuck with AI negotiations from 2023. So the Writers Guild Association just got a new agreement which left in place the status quo, which was that writers who were concerned that maybe, and I'll just say with a footnote, Most writers are not that concerned that AI can replace them yet, because AI is writing terrible scripts and terrible jokes. But there is a concern that maybe AI could generate first drafts, which would reduce the staffing. And there's very clear collective bargaining agreements now that say you can't reduce staffing, you can't have AI generated scripts, though you can use AI if supervised by writers. And that status quo has been left in place. The open question is whether writers can get compensation if AI models use their writing. And can the studios that might hold the copyrights in the writing license that for training, profit from it, or create AI models to generate scripts based on writers' work? And there's sort of a detente there, right? So the studios are not willing to compensate or agree to compensate for training, but have agreed to disclose any licensing deals and to keep talking about that issue. The biggest in the entertainment industry, I would say, discussion around AI is largely the actors, the SAG-AFTRA, and then the recording industry, both performers and record labels. And so I'll talk a little bit about that. SAG-AFTRA, the main actors union, is negotiating its new 2026 deal. Their concerns are very reasonable that AI could regenerate a performance of someone and you wouldn't need to rehire the person. Copyright might even allow this because you have a fixed version of someone's performance and then you could reuse it in a new performance. As I mentioned, this is not new, this is old. And so while consumers can now create these performances too, the studios have been able to do it for a long time and largely have not done so and largely have gotten permission, in part because we have a lot of laws that cover that already. But the collective bargaining agreements also limit the reuse of actors' performances. A lot of the calls for new legislation, and I think we see a hint of this in the IP provision in the AI framework, calling for what sometimes is called a federal digital replica right, comes from the recording industry. Some people may remember a few years ago what was called the fake Drake. And this was an AI generated version of a song that hit the top of the Spotify charts and sounded like Drake. And people thought, and there was some lyrics from Weeknd or voice that sounded like Weeknd as well. People thought it was a duet between Drake and The Weeknd. It turned out to be completely AI generated voices, though notably a human being actually composed the music and wanted to show off his music writing skills and get attention by using famous people's voices. There was an outcry after this, not because Drake or The Weeknd wouldn't have claims, because they did. They had a bunch of claims, but because the record labels weren't sure whether this was an infringement of the copyright in the underlying recordings, which would have taken a long time to litigate, and were worried they wouldn't be able to bring the right of publicity claims or Lanham Act claims on behalf of Drake or The Weeknd. And this is where there was a sort of spate of state legislation, starting with Tennessee, involving Senator Blackburn, which is why there's some interesting preemption provisions in the legislation that's been proposed. But notably, during this period of time, the record labels filed a whole bunch of suits against AI generators of sound recordings. And one of their claims, which was fascinating, was that the replication of voice sounds was also an infringement of copyright, and they also asserted the performer's rights. But notably, almost all of these lawsuits have settled, or the big record labels have settled, and have settled with agreements to generate AI generated music, which is fascinating, right? So they were using concerns over the underlying recording artists, but then made deals to generate music using AI without necessarily, both with Spotify and some of the other companies, without necessarily protecting performers. And so I probably talked long enough about that background, but hopefully we'll circle back to some of the proposed federal legislation that tries to address particularly this digital replica right and raises a few questions I have about the proposed framework.
That's there's a lot there. Ioana, you wanted to respond
Yeah,
directly?
I just wanted to react that, one thing that's really fascinating in all of that is the important role of unions here. And we have to remember that most American workers are not unionized. So they are not able to engage in negotiations with their employers over how AI shall or shall not be used in their occupation. So I think that's really an interesting wrinkle. And then the second quick thing I wanted to say is that while I was working at the DOJ, we worked on the Live Nation Ticketmaster case, and I got to learn a lot about the recording, the music industry. And one of the things I learned is that nowadays most artists make most of their income by live performing, not by selling their music online or through records. And so I think that really underscores the importance of my distinction that I came in with regarding, is this an in-person activity or not? And if it's an in-person activity, you can continue doing this activity and perhaps expand it and charge for it. And if it's virtual, that's much more complicated. But there, the artists have unions to negotiate on their behalf. Also, some of the artists are a brand in themselves. So, they could have a lot of negotiating power. But if you think about the ordinary worker, they're not necessarily in a position to negotiate over these things. And, they have to turn to the market and potentially other supports that we can offer, such as AI, or essentially support in terms of training, unemployment insurance, and the like, if they need to change jobs.
And yeah, this is great. And another, I think, a takeaway from what you started off with, Jennifer, too, I thought is worth putting out on the table as we start off here, is that AI means lots of different things. As you said, it's been around in the entertainment industry for a long time. I often say it's not a technology, but a suite of many different technologies, and that's worth keeping in mind. Your comments also, I think, raised a wealth of ways in which AI is raising issues in the entertainment sector, but that's true in so many different sectors as well. And it makes it challenging to think about legislating in this realm. It also means that with the wealth of technologies and the wealth of issues that are raised, particularly on IP issues, on labor issues, that it's a good time to turn to Christopher, because I know he'll have thoughts on some of these issues that we've been talking about as well.
Gary, but I just want to say, since this is a conversation, imagine if somebody was just impersonating us with avatars right now, and you're not listening to a real conversation, it's all AI. So that's the sort of thing that you can do with the technology.
Well, we're at the point now where no one should be confident that's not happening.
Yeah.
We all could be avatars. Don't worry, we're not. But
but what would an avatar say? But that's what an avatar would say, right?
Well,
anyway, Christopher.
It's funny. I mean, it is an interesting world, but so there's no question that among our students, the anxiety level about the labor market impacts of AI is extremely high. I can't, but it's not just because we're professors and we're thinking about it. When I've talked with various leaders, this is very much top of mind of leaders all over the world. And it's very easy to panic and to assume that there's only one inevitable solution to this, or one available outcome. There's actually some interesting scholarship that suggests otherwise. And now there's an empirical macroeconomic literature that suggests that companies that employ more AI are employing more people. Now, granted, it's early transitional, and like all empirics, there's going to be different studies with different methodologies, and there's going to be a certain amount of tension. But there's enough variety that it's unclear what the outcome is going to be. But there's a really interesting theoretical piece by economist from University of Toronto, economist Josh Gans, which I really was taken by. And the point he made is that AI is about prediction, and it's about improving our ability to predict. And that's, in fact, complementary to judgment in many cases. And by reducing the cost of prediction, or about improving its quality, there's an interesting demand side effect which has to be taken into account, which is, if basically there were no further gains to expanding the things that we couldn't do before, the ability to do what we did now cheaper will cause us to substitute to take the gains and put them in our pocket. That is, take the fact that it's now cheaper to do the things we used to do, and we'll do less of it because we don't have to do the same levels we did before. There is another possibility, which is that there are further gains to be had by expanding our output and by our efforts in those dimensions, and that in fact it was the high cost of doing that was holding us back. In that scenario, the fact that it's now cheaper means that we will expand those activities and do more of them because we can now reach markets and reach activities we couldn't do before. And there's a book by computer scientist Arvind Narayanan from Princeton who actually gave a really nice example of this about automatic teller machines, good old-fashioned ATMs and banks. Many people predicted this would reduce the number of bank tellers, because why? We're going to get rid of them. We're going to substitute for them with automation. Empirically, actually, it led to an increase in the number of bank tellers. Why? Fewer tellers per branch, but more branches. Why? It was cheap, reducing the cost of doing business, and there were further gains to increasing the number of banks that we actually saw a net increase. And I would say it's probably too soon to see what the net effect is going to be. It very much reminds me, if we were sitting in like right before the dot-com bubble in 99 burst, did we know then that was the death of all travel agents? Probably not. There were new business models. It's a $1 trillion economy that we didn't see coming. And that, in fact, there were many business models that were tried in the mid-90s that failed that are now ragingly successful, which they're good ideas, they're just before their time. And so what we're going to likely see here is, will there be winners and losers? Yes, there will be things that aren't jobs anymore. But what the net effect is going to be remains to be seen. But the other question is how fast this is going to change is also up for grabs. So Arvind Narayanan made another point in his book, AI Snake Oil. He said, AI replaces tasks. Jobs are bundles of tasks. And they may take months to years to re-engineer, as opposed to how quickly some of the people are predicting AI will change specific things. I think that's all too soon to be, the story is yet to be written. And that, in fact, at a time where we don't even know what business models are going to be profitable, and we're seeing new technological innovations that are radically changing the way we're doing things, that we still have more questions than answers, and that, in fact, doom and gloom may be a bit premature. Carey, you're muted.
Yeah, let me turn back. Yes, let me turn back now. Let me shift gears a little bit. Since we covered, at least initially, one of the key parts of the national policy framework dealing with workplace issues, let's look at another one. The first one itself is dealing with protecting children and their safety when they're online or using AI tools. Others related to safety more generally. And I guess I've asked Kevin if you could jump in on this and let us know what you see. There's obviously some action at the state level on safety, AI safety governance. What should the federal government be doing with respect to AI safety? And is what's outlined in the Trump framework moving us in the right direction?
Thank you. No, I wanted to pull us back to looking at the legislative framework because we've heard a lot of really valuable insights about things like labor market effects. But given all the uncertainties that everyone on this panel has talked about and the work that's going on, the real question is, what should the government be doing? And in that area, you look at what's in this legislative framework. It says a little bit of training, a little bit of research, some demonstration projects at state land-grant universities. If we're talking about something as potentially disruptive and transformative to the workforce as AI, even if we're not sure there are going to be those serious consequences, this is the time for a concerted research effort, a real grand challenge to expand the work that researchers are already doing. And yet we're in an environment where the administration is cutting funding for research. There are these policy alternatives, like some of the ones Ioana has proposed, others have proposed universal basic income. Those are the kinds of things that we should be investigating at this stage. And to answer your question, my concern when I look at this legislative framework that the Trump administration has put out is that it's simply not adequate to the task. So you mentioned the issue of safety, and when I think about AI safety, I think about the broad concerns of severe harms that may come about because of these AI models and systems. And the problem is that these concerns about AI safety have been politically associated with a movement that's been around for a long time, worrying about existential risk, about AI superintelligence, funded in many cases by people who are associated with a philosophical movement called effective altruism. And that's absolutely true. That those are some of the people and organizations that have been pushing these issues for a long time. But the reality is, if we talk about AI safety, we need to look at what's actually happening. So just a few weeks ago, Anthropic announced an AI model that is too dangerous to release, that is so good at finding zero-day vulnerabilities in software systems, including critical infrastructure, that they were seriously concerned that just to put it out to the market would lead to catastrophic harms where hostile actors take advantage of this to exploit vulnerabilities. So they announced something called Project Glasswing. They brought 40 companies together, including some of their competitors, to work on using this model to patch those vulnerabilities before they're exploited. Now, the scary thing isn't that particular announcement. It's that even if Anthropic is a little bit ahead of its competitors, they're all going to catch up and very soon have models as good or better than that. And it's not just the Anthropics and OpenAIs and Googles of the world. There are several companies in China that are making available open weights models, openly available AI models that are just a few months behind the major US frontier models. So this is just one example of we're now in an environment where we need to think about the possibility of mass scale risks from these AI models. We're also in an environment with tremendous benefits and potential benefits from these models, but we need to take those concerns seriously. And there's essentially nothing in this framework about safety in that sense. You're right, there is language about children because that's an important concern. There are terrible situations that have happened where teenagers have committed suicide after long conversations with these conversational agents. And those certainly deserve attention. But that's a major concern that has gone to the top of the list basically because of the political salience as opposed to the scope of the risk. The framework talks about the fact that national security agencies should have the technical capabilities to understand these issues, which of course is certainly true, but it doesn't propose any action. And in fact, the preemption section, that last section, would overturn the two laws, the RAISE Act in New York and SB 53 in California, the only two major laws that have been adopted in the US requiring these model developers to make available safety and security plans, which honestly the industry is generally comfortable with. So I'm concerned not just with what's in this framework, but what's not. And that it's not focusing on the most serious issues. If you started from a blank sheet of paper and said, what should we be including in a legislative framework for AI today? That's where I would start, not with the list that's on the table now.
Jennifer.
I agree with what Kevin said, and I also want to focus on, even on its own terms, the framework is contradictory and in tension with itself. So just taking sort of part one and the focus on children, for example, there is a suggestion that it doesn't want to preempt state laws in this space. But then the last part on preemption says we sort of want to preempt stuff in this space. And if you look at the proposed legislation that I mentioned earlier, the No Fakes Act, which is short for, I have to actually read it because it's long, the Nurture Originals, Foster Art, and Keep Entertainment Safe Act. And I highlight its full name because although it focuses on arts and entertainment, it applies to everyone, ordinary people. everyone joining this webinar, everyone on the webinar, and children, whether they're actors or performers or not. It would apply to everyone, and it would create a federal digital replica right, a right to control your likeness and voice clones and potentially deep fakes. Before sort of drilling into that, this legislation was thought to potentially not be going anywhere until the issuance of this AI framework. And the inclusion of the call in the IP provision of the framework for a Digital Replica Act, the protection of children from sexual exploitation, seniors from scams, and then the preemption provision are all trying to be sort of squished into this legislation and to have legs. And what's largely driving it is actually the preemption provision in the No Fakes Act, which was stripped, as Carey mentioned, from the big, beautiful bill. And so here are the sort of internal tensions. The first part of the framework says we want to protect children, and we've already done so through the Take It Down Act. And second, we're not going to preempt state laws that might protect kids. Well, they exclude sexual state legislation regulating sexually explicit content in the No Fakes Act, but the preemption provision would preempt all of the new legislation after January 2nd, 2025, including regulations meant to protect children and minors from chatbots, as well as a host of other protective AI regulation across the country, as well as potentially any causes of action arising out of uses of digital replicas in AI that are brought after that date. The language in the No Fakes Act is somewhat unclear. So there's a bit of tension there, and even the Take It Down Act could be thwarted by the No Fakes Act, in part because it would allow the authorization by parents and by authorized representatives of sexually explicit works, even if the underlying person didn't specifically agree to them, which seems to thwart the objectives of Take It Down, which is about taking down sexually explicit works. In addition, the AI framework doesn't address the fact that Section 230 of the Communications Decency Act was recently held to eliminate any obligation for platforms to take down sexually explicit works and content, in spite of the language in the Take It Down Act that says you have to take it down. So the AI framework is, as you say, it's not up to the task of protecting children. And the section, I think it's Section 2, on protecting and safeguarding the community, is also overlooked in the proposed legislation that this framework purportedly supports, because one of the main concerns is about deceptive uses of deep fakes. And again, the proposed legislation here, the No Fakes Act being the main one put forward, doesn't care at all about whether the public is deceived. Right? That's not even a consideration. And in some regards, by commercializing digital replicas and allowing someone other than the underlying person to authorize them, or even allowing the underlying person to authorize them, but in a deceptive way, completely thwarts the stated objectives in Part 2 and creates a tension with this sort of IP framing later on in the framework.
I'm going to ask Christopher to go next, but before I want to just remind everybody who's joining us on the webinar that if you have questions, please enter them in the Q&A portion. Find that on the Zoom platform and enter your questions by typing them in, and we'll be turning to those in a bit. So, Christopher.
So, I accept, and if a matter of first principles, what Kevin and Jennifer are saying, we should actually look and see in a blank slate, what should this include? And I agree, it's not exactly a comprehensive plan, but to take it in a different way, if you look at where this is coming from in the path, the evolution of policy coming from the Trump administration, and in particular in light of the first Trump administration as well, it's kind of, maybe there's something we can learn from that. So what we saw was in the first Trump administration, towards the end, an executive order that was never fully implemented, but also from the very beginning, a series of the executive order that really focused on a completely different set of issues. National competitiveness, removing regulatory barriers, U.S. leadership, And if J.D. Vance at the AI Summit famously saying, "The days of hand-wringing over AI safety are over." This document, and nothing about workforce, this document is different. It may not be hitting all the notes about safety, but at least there's a presence of safety. There's a presence of workforce. And one of the key essences to me is, particularly in this environment, it's inherently a political document. So I don't disagree with you, Jen. There isn't a lot of coherence to this. If we interpret it as a political document, it's an attempt to cobble together a good old-fashioned horse trading coalition of appealing to different people who have primary issues that of across the spectrum to try to generate support for the what many of us interpret as his primary emphasis, which is preempting state law, which he's now attempted to do in legislation twice without success. And maybe he's hoping that he can put together, or the leadership is hoping they can put together a coalition enough to do that. In which case, I mean, the lack of coherence is good old-fashioned politics, DC style, and is nothing new. And that's not intended to be, a slam. It's really a pragmatic acknowledgement that's how often law gets made. But I do see that it is a sign that this administration is recognizing that the themes it put out in the first executive order, really looking at U.S. leadership and competitiveness and deregulation, frankly, may not be getting enough to get what they want. And is a recognition that they have to broaden out their coalition and deal with different issues, perhaps not because they're deeply committed to them, but because they pragmatically see that as a way to accomplish the goals that they do hold, place a great deal of priority on.
Christopher, would it be too much to put you on the spot to say whether they're headed in this horse trade is at least headed in the right direction or not?
Well, I mean, I honestly don't believe there's almost any degree of enticement you can put on the table to get legislation through in the current environment. Part of it is we have, as a country, voluntarily picked up such a wide number of issues that consume us, that are bigger in many ways in terms of legislative days. The other thing that I've just become really struck with, and it's made me feel sympathy for congressional leaders over the last decade or two, is that I find the leaders in both houses unable to cut deals because they can't count on their caucus to vote behind them. And that, in fact, it's an increasingly polarized society where we actually can't, the deal is not only that the leaders are unwilling to meet in the middle, I think they can't because they don't have a reliable ability to deliver the votes. And so in this environment, maybe there's a vehicle that has to go through, you could do something, but I have to admit, it's a tough environment, and even looking at the 7 notes they hit in this, I have a hard time seeing that would be enough of a coalition to get it over the hill. But a lot of things happen in politics, so you never know.
Okay, I've got Jennifer and then Kevin who want to jump in.
So I think Christopher's right that one of the reasons it's somewhat contradictory and incoherent is because it's trying to appeal to so many different constituencies and try to drive through the preemption of state law provision, which is actually what I think the administration wants, and which there's also a lot of support, particularly in the tech company world, to pass. But I think I want to harken back to something else Christopher said earlier, which is that the technology is changing rapidly. So I always think it's a dangerous business to legislate around rapidly changing technology. There are lots of stories in the IP world of specific legislation about a particular technology, for example, the digital audio tape, that became obsolete essentially by the time the legislation was passed. I think there's a second danger here, which is, and perhaps highlighted by this framework, is that there are lots of appealing things, like who doesn't want to protect children? Who doesn't want to protect seniors who are being scammed? Who doesn't want the US to be a leader in innovation? But, right, the proof is in the pudding. So when you operationalize this, are we on the surface saying we're doing one thing, but the legislation is actually doing another thing? And so thus far, what I have seen floated is either legislation that can't get passed, or legislation that, if it gets passed, would be struck down as unconstitutional, or legislation that would work at cross purposes with its stated goals, but might further some unstated goals, although in this instance they're very clearly stated in the framework, which is the preemption of state laws regulating the space and significant platform immunity.
Kevin?
I would also highlight some other things that are not in this plan. Jennifer is absolutely right. Passing legislation is incredibly challenging in this environment, and a lot of the proposals that have been floated, even if they were adopted, wouldn't be upheld. If you look at what it is
can I interrupt for a moment?
Sure.
I'm sorry. Ask maybe a clarifying question for both Jennifer and you. What are those aspects of the framework that might not be upheld? Can you give us some examples?
Oh, so the framework is too general to say that. I think some of the issues are some of the legislation, for example, in terms of age gating for children, some of the legislation about political misinformation and so forth. There's, some of the state laws have already been enjoined on First Amendment grounds that are trying to limit speech in various ways. So those are some of the issues that I think about in that context. But the bigger problem is just getting something adopted.
Okay.
What's actually, the industry certainly would like less regulation, and especially if we're talking about the industry in terms of the major AI companies. But what they're looking at, they're staring down the barrel of massive potential private liability, which is not from legislation, but the role of legislation is potentially to shape and limit and change that liability. So that's what's going on with intellectual property outside of the digital replica issues. If you look at what all the AI companies said in response when the Trump administration early on did a request for comment on what should be in its AI policies, even before the July AI Action Plan, Anthropic and OpenAI, all these, what did they talk about? They talked about their risk of liability for IP lawsuits for their mass scale scraping of data. The framework says essentially the Trump administration believes that's fair use, but Congress shouldn't do anything. We should let the courts resolve it because there's internal contradictions in the Republican coalition. Anthropic's already paid a $1.5 billion settlement over some of its data acquisition practices. This is an area where there's great concern, and yes, it's about liability under existing copyright statutes. But back in 1998, we adopted the Digital Millennium Copyright Act when the internet raised these questions about liability. It created a notice and takedown regime and so forth. It's far from perfect, but it was a way of legislatively addressing this problem. But it's not just about copyright. There is already a huge number of private liability lawsuits being brought against AI companies. Many of these involve some of these issues with children. The Gartner Group just put out a number that they expect 2,000 wrongful death lawsuits over AI by the end of 2026. Now, some of those are things like suicide. Some of those are things like AI-based medical advice leads people to situations where they die.
Refusing care or something.
Whatever
like that.
It is,
Yeah.
the point is, This is America. When bad things happen, people sue, and actually, private liability is the only thing so far that has been guaranteed to substantially change the behavior of major tech companies. The Illinois Biometric Information Privacy Act, which was passed with little fanfare in 2008, because it had a private right of action, got Facebook to dramatically change its facial recognition policies. And so this is an area where, again, we're talking about tort law. So we're not talking about something that is created by congressional legislation, but legislation could shape the liability environment. So, for example, there have been proposals for what are called independent verification organizations, where the government would authorize private certification authorities. And part of the carrot that would be provided for companies to get those certifications is some measure of protection against liability. Now, there's a lot to work out here and a lot to talk about, but this is a direction that's actually focusing on what the real issues are. And again, you won't see anything like this other than preemption in the framework.
But I wonder if these liability risks the combination of the maybe cross-cutting or inconsistent or incompatible state patchwork of rules, wouldn't that maybe, if not this year, but at some point, give rise to enough impetus for the industry even to be able to accept a range of other controls on itself at the federal level to try to support a grand bargain that would be palatable to enough of a coalition, Christopher, to break through the kind of problems that you were discussing? Do you see that possibly happening?
It's possible, but we've been saying the same thing about privacy for a long time with the advent of 20 state privacy laws, and it hasn't led to a coalition yet. I mean, it's easy to see the impetus, but getting to the deal and the contents of the deal, it's not just preemption and private rights of action are huge. I mean, those tend to be the major sticking points at this point on a lot of these different matters. And the other problem, there's a general lingering feeling that we could really mess this up. So I gave a talk at the Silicon Flatirons program. We were talking about AI liability, and maybe for the first about AI and competition. And for the first, and I said to be, it's not the time for ex ante regulation. And both, and for those of you who know what how important this is because of the fights have been, both Tim Wu and Rick Witt agreed with me. I don't think that's ever happened in my life, in a sense that, and so, but I do think that even there's a conviction that we might need to do there are some issues that we need to address here. I think we are tending to do the route that Kevin's suggesting is good old-fashioned ex post tort liability as a fairly supple means for doing it. I have some writing that talks about this in terms of when do we use what we call standards instead of rules. And it's when it's very fast changing, unstable, multifaceted in ways that it's not naturally susceptible at this time to write the kind of broader prescriptions that we might need. And so what I find is that thinking, yes, there may be some political impetus to it. There also may be some political reluctance from a concern that crafting rules right now might not be the right thing. On the other hand, the DMCA happened very early and managed to create a workable accommodation. Remains to be seen. The last thought I'll have is I keep thinking about how the Copyright Act of '76 was started in '64 and was stalled for a dozen years until two Supreme Court decisions got the entire broadcast industry basically on board with change. So there may be some big bang judicial function that may change everything.
Jennifer.
Yeah, that's a great segue. I just wanted to amplify what Kevin highlighted, which is this comment about fair use. And also in that same provision about IP, a call for a collective licensing system, right? Something akin to sort of what's happening with sound recordings being played and royalties in venues, and sort of compulsory licensing regime. And I think that may have traction, although it may wait for some bad court decisions, bad depending on your side. But also sort of maybe one of the most exciting things that has happened in sort of copyright land is the Copyright Office conflicting with the Trump administration about whether the training of AI models on copyrighted work is infringement or fair use. And people may or may not recall that there was a report that was released, sort of a pre-publication version that was released before the attempted ouster of the head of the Copyright Office, in which the Copyright Office went on record saying that this was not fair use, right? It was not like Google Books where you're just like ingesting some material and then putting out little snippets. It was something that crossed the line into not being fair use. So I think it's fascinating the way this framework is drafted, both to say we still think it is fair use, but we'll let courts do something. But really, what we need is collective licensing. And I think collective licensing is probably being heavily considered behind the scenes right now, and it may be ready. Should some court decisions find that it is not fair use, for that to slide in. And there's so far trial courts are split on whether it's fair use or not.
Well, and also I guess in all of this, I would say if we're thinking about what might get a coalition built around might be, going back, Ioana, to your point earlier about at least gathering some more data and information. Maybe we could see something on that front. I want to turn to questions that are coming in from the audience and encourage others who have questions from the audience to enter them in the Q&A. But one question that kind of builds on what we've just been talking about, I think is a fascinating one. The question is, when it comes to the AI policy framework and its different parts, or all the different facets of AI governance, maybe the ones that are left out of the framework, as Kevin was saying, what parts do you feel like we cannot afford to get wrong? And can you give an example of what might happen if we do? And ultimately, is that risk enough to try to unify legislators to try to do the right thing? Jennifer?
I think others will have other contributions that are important. I think some of the security stuff Kevin highlighted, getting that wrong is a really big deal. I'm going to highlight getting wrong who owns your digital self is pretty profound. And so to the extent in trying to solve some commercial losses, if we erect a federal law as being proposed that could allow people to lose control over what's done with their voices and performances and likenesses, and to deceive the public as to the authenticity of performances, I think that would be a profound loss for our society.
Ioana?
So one concern that I have is, well, I don't think this is the most likely scenario, but if there is a significant but minority portion of workers that do end up permanently job loss, a permanent job loss, and they just can't find a job. Unfortunately, right now, most of our social safety net in the US is predicated on having a job or looking for a job. And therefore, these people would be left with essentially nothing. And so, if that were to happen, again, I don't think that's super likely in the short run. I think we'd really be in trouble from a social perspective. And it's also not clear that this would be addressed quickly, because if those are not a majority and, they're unproductive, so like, who cares? These people don't necessarily have the power to change things. And so that's something I'm really concerned about. And we don't know exactly who that would be. So I just want to point out, we're a bit behind the veil of ignorance. So I'm hoping that right now we can think about how to guard against that outcome by putting in place a flexible policy that would deploy like a parachute, if something like that were to happen.
Christopher?
So what my fear is that we misunderstand, we create regulations that don't take into account that predictive analytics is probabilistic, and that it, even at 99.999% accuracy, means guaranteed errors 1 in 100,000 times, which is at scale huge. And so what you find is that we need to be having a very candid discussion about acceptable levels of risk, because the only way to have riskless AI is not to have it, because it's just irreducibly the nature of correlation engines in doing that. And there's a tendency that people in the discourse have to hold AI to a perfection standard, when really we should be looking at real-world counterfactuals to see what the alternative is. I mean, turn that into English. When we look at autonomous vehicles, the counterfactual, if we don't do AVs, is people. And people are bad drivers. I mean, we make mistakes. We have an error rate, and the real question isn't are AVs perfect, but compared to the baseline, whether they, what is relevant. But also, to me, there's a question of the costs and the risks. So I quote you all the time, Carey, you taught me something, that the first use of AI by the US federal government was handwriting recognition by the Postal Service. This is an area where the potential gains in terms of costs are mundane costs are high. There are some small risks, but in the grand scheme of things, I think there's more manageable. But even in higher risk environments, there's a project that I'm doing along with Seoul National University, led by Liem, who is my colleague who's working on this, who's actually in attendance. Our healthcare person is Nicholson Price, and he gives a great example. There is a stroke drug that, if given to people within, fairly promptly, like within a minute, is incredibly efficacious, is very cheap, and has no adverse consequences for healthy people. And with that risk profile, not so much because it's riskless, but because the benefits to a very tragic loss might be very high, is that we might see cases where we want a broader use of artificial intelligence and not do the human in the loop solution that we constantly resort to, but actually say maybe in that risk profile we cut things loose and let them have a mechanism for realizing the benefits by doing this sort of cost-benefit analysis, understanding that there are acceptable levels of risk, but there are also compensating benefits we have to take into account. And we need to be more context-specific. It'll vary by sector, and even within sector, it'll vary a lot based on the uses. But I think that there's a discourse that can be beneficially happen that can be sidetracked by taking a very flat view of AI and picking, admittedly, very tragic consequences, which we need to address. But in fact, if we just look at some fatal situations and make that sort of the entire touchstone of our analysis, I think we might lose some of the benefits that we might see here otherwise from AI.
I would also add, by the way, one other thing I've mentioned before, which you didn't refer to, but I think it's compatible with what you're saying, is we not only have to think about whether AI is perfect or not, we have to think about it whether it's how it works compared to what. And humans make errors too, right? So we have to recognize that. Ioana, you're next.
Yeah, well, I just wanted to say, as an economist, I can't disagree that you have to calculate the costs and the benefits. Hooray for that. That's really important. And at the same time, I think part of what's happening with some of the reactions we see in the public or policymakers is a somewhat orthogonal problem about trust and the quality of our institutions. Because you can say, oh, there's a cost and benefit, but who gets to decide, and who gains and who loses is really important. So it's useful, but not enough to calculate the average cost and the average benefit. But we need to think about procedurally, how did we get there, and who's getting affected? And unfortunately, there's a lack of trust from the public in the institutions and in AI at the same time. And so I think that's a critical thing that I would love to set out to improve on, to improve the trust by deserving the trust. So that seems like a critical challenge.
Kevin?
If I could just jump in there briefly. So I've talked a lot about risks of AI, but what I wanted to say is what we also should be very concerned about getting wrong is not facilitating the development and adoption of AI, and especially the leadership in AI by the United States, if we're talking about a U.S. policy framework. And that's why I highlighted things like the fair use concern, because that is what the AI companies are worried about, is an existential threat, open-ended copyright liability. But that's also, what Ioana said is very important. The other great threat to them is lack of trust, is popular outcries, people being scared. That's what's fueling some of these pushback efforts on data centers and other kinds of limitations. So we absolutely need to be focused on what could go very badly wrong, but we also need to ask what could really hamstring AI development. And we always need to keep in mind the global environment and the competitive environment with China. And again, that's something that we're not really talking as much about here when you look at this framework. And I think it's really central.
Well, that's one of the questions that was asked in the Q&A about how the U.S.-China dynamic should factor into congressional thinking about AI legislation. Jennifer, I know you had your hand up earlier for something else, but let me turn to that and put out on the table if anybody wants to talk about the geopolitics dimensions of domestic legislative development.
Well, I agree with what's been said about we do want to be leaders in AI. It's a tremendously useful tool, which I think gets into the geopolitics. But as we think about legislation, and this goes back a little bit to what Christopher said, he mentioned sort of different contexts are going to be different. And that doesn't mean we should legislate necessarily for all the different contexts. Not only is that more likely to be unconstitutional, but it also is likely to fail because we'll always be behind in our legislation. And so I think one of the things that this framework doesn't address, that a lot of the legislation that's being put forth doesn't do, is take a step back and say, do we already have laws on the books that affect this? That would regulate it in ways that would be helpful. And Kevin mentioned a number of ways where we have existing laws. For identity rights, we already have existing laws. For some of the IP, we already have existing laws that we may not know how they play out. And we don't yet know where the fails are going to be. And so it's sometimes hard to sit with uncertainty and concerns and worry. And so people want to rush to legislate. But this may be a place where we need to also sort of be aware, but wait and see if we need something beyond sort of generally applicable laws. And I think this is worth mentioning the Communications Decency Act, Section 230. Some people think it's great. Some people think it's the worst thing ever. It was passed after one pretty terrible, wrong trial court opinion that other courts disagreed with, and that probably would have been adjusted about platform immunity and regulation online. And what happened was the rush to regulate and make sure that the internet flourished, which was a good idea, shut down sort of the common law development that would have been more nuanced and been able to adapt as the technology itself adapted. And instead, we locked ourselves into a rule that still, I think, is causing us some problems, as we see with the Take It Down Act. And so I think we could try not to repeat that same error by reminding ourselves that we have all these laws that apply to AI. There's not like an AI exception to general laws, and then see where the problems arise as things develop.
That leads to, I guess there's others who want to comment on it. Christopher?
On sovereignty in particular, just briefly, the standard assumption that many people have is China versus the US. And it looks like the old Cold War where we had different scientific establishments in the old Soviet bloc and the US. There's something different going on in this discourse, which is about AI sovereignty. And it's partly about the technology because it's tied to language, which is really, it's not just tech and big iron and all this other things that we normally do. It's very much tied to the individual countries and the heterogeneity among them. And there's a huge push in all these other countries, not simply to fall into the orbit of one of the two leading countries here, but to actually develop their own. I think ambitions of having the entire stack, I'm sorry, we have 190 plus recognized UN countries. We're not going to have 190 chip manufacturers. It's not going to happen. But at the LLM level and different things, there's a lot of interesting dynamics going on. And there are countries that are so small they don't actually have language corpuses enough to have their own AI. And in that case, their only solution is to piggyback on stuff developed for other things and then translate back and forth. And it's actually fascinating to me. For example, Iceland is cooperating with Google because the corpus of 300,000 Icelandic speakers is not enough to generate the kind of text to develop it independently. And so what I'm seeing is a much more complex interaction where, in fact, it's not going to be as simple as the China versus the US.
Kevin?
And then I think Ioana said something she wanted to get in. Two things on US-China. One is the argument of this administration is that regulation is what's holding back US AI companies. China is regulating AI much more aggressively than the United States in all sorts of ways, including for safety and accuracy and bias and things like that this administration is explicitly rejecting. And they don't seem to see a conflict. They seem to see it as important for trust. So that's one thing to think about. The other piece, though, is the U.S.-China competition is really important. And so you think, what are the U.S. potential advantages in this competition? One is the Silicon Valley tech innovation ecosystem. One is compute. China's AI companies are compute constrained, and that's a material reason why they're behind the U.S. frontier model companies. And so, therefore, it's difficult and challenging and complex. But using U.S. leverage about advanced GPUs and semiconductors, I think, is something important that needs to be in the policy toolkit. The other one is people. If the best AI researchers in the world want to be in the U.S. working for U.S. companies, the U.S. will be the world leader. And that includes many, many Chinese researchers and Chinese American researchers. And that means immigration. That means an openness to having the best people in the world come here. And so that's also a tension with a lot of the direction of this administration. But I think if we really care about the U.S. Leading the world, there's a lot of cooperation with China that's really important. Then that's what we need to focus on.
Inclusion is also a dimension that would provide an environment where people would want to come and be open. Ioana.
I just wanted to add that I think in the sometimes obsessive thoughts about competition between the US and China, I think there's one dimension that is not talked about enough, which is why is it so important to win? I mean, look, like everybody, I love to win, everybody loves to win. But the question is, how important is it? Like, again, let's quantify that. And I think part of the obsession comes from the belief, which I would like to question, that there's going to be the singularity or something along those lines. That whoever gets first there, and we don't even know what the there is going to enjoy an overwhelming advantage. And I want to talk about it from an economic perspective, that somehow maybe once you get there, you're going to have an increasing economic growth and nobody can catch you anymore. So if that's the case, it is somewhat justified to be, I want to win, because then you're the one. But if that's not true, then, it's just an order and the other guys are a little bit behind. And, sure, it's nice to be ahead, but it's just a matter of degree. And I think, there's reasons to question that you're going to have this acceleration because, according to my work, you can't just live with AI. There's a lot of physical infrastructure in particular that limits the potential for AI to make a big difference to economic growth. So I just want to open this up, that how important is it to be first really relies on what do you think is going to happen if you're the first to get there? What is the effect of that?
Let me shift to another question that I think may be somewhat related here, and that is, and maybe it's a short one that we can deal with, and then we'll move on to another one. But what's not in the framework? A couple of questions asking about whether concerns about the environmental impacts of data centers on communities, is that addressed in the framework? Are concerns about racial bias in AI, is that included in the framework? I think it's a short answer. The framework does refer to protecting communities from harmful impacts, but it doesn't really say anything more about what type of impacts those might be. I think at best it's higher energy prices, but not necessarily the whatever water usage or emissions from additional energy consumption that might be attributable to AI. And on the racial bias issues, I don't see anything there either, and would be surprised, I guess, if the administration wanted legislation in that regard. Is that a fair brief synopsis, Kevin?
To the contrary, there's language about censorship, which in this administration is a code word for pushing back on racial equity and bias initiatives. So it's actually suggesting states shouldn't try and address those kinds of issues. But you're right, on the data center issues, there's some language about energy costs as opposed to the broader environmental ones.
Christopher?
So it's interesting. So I think that the truncated view on safety about kids is too narrow. I think that there's a broader conversation to be had there about, but I think, part of it is we don't really understand that, like any tool, it's not useful everywhere. And understanding what we have to do to enable proper uses and disclosure to people, I think it needs to be done. In addition, people hack through guardrails. And most guardrails that if you push on them hard enough can be evaded. And sort of understanding an allocation of responsibility. So I mean, to take a weird example, my wife used to work for General Mills, and they were trying to do a premium where you're going to make a birthday cake inside, a Betty Crocker birthday cake. And the general counsel's office took the position that it has to be, the product has to be so safe that you can nuke it for any amount of time and it won't catch on fire. As a matter of physics, if you put something in a microwave for long enough, except for water, it will catch on fire. And so, I mean, sort of setting up this sort of discussion.
Don't try that at home, folks.
No, absolutely not. So the thing is, a discourse about understanding the allocation, that there is such a thing as misuse by the consumers with proper warnings, and to understandings, put some limits around it. I will say something that may be controversial as well. I actually think my hope is that the environmental issues, first, it is all about electricity prices, which is a very narrow vision of environmental issues. I'm hoping these will be transitional, because to me, these data centers are begging to self-generate. You know what I mean? Because if they want a kind of facility that runs 24 hours a day, is begging for self-generation in terms of electric power, because it's got a steady, useful, sink in terms of what it's doing. And I think that we're seeing some dislocation because we're seeing the advent of data centers all over the place. But with proper siting and with proper development, not even for public uses, but even just on a limited basis, I think we may see in the medium term those problems be less acute than some people may think. At least that's my hope. It's a real possibility to me.
Well, we're zeroing in here. We've got time if we can be quick on one more question, and that is, what can the federal government be doing to promote innovation in this area? Should it be doing anything to promote innovation in the AI space even? Obviously, the Trump framework, I think, has the idea of a lighter touch regulation will simply let 1,000 flowers bloom. But is there anything else that should be considered if Congress gets into this picture that would help promote responsible AI development and innovation?
Funding for the underlying science, which again is in conflict with the larger direction this administration has taken. And again, if you look to China, China has been very aggressive in what they call AI plus. They're talking about promoting innovation in deployment and adoption and diffusion of these technologies. We get so focused on the capabilities of the model. I think there's a lot of scope for innovation in terms of how can public sector agencies leverage this? How can small businesses leverage this technology? And I think that's an area where government can play a role in ensuring not just the responsible use, that the real innovations happen in terms of the impacts of AI.
Christopher, you had your hand up.
So one thing I think the government could be doing is understanding that that AI is usually delivered by a vertical stack of companies. I mean, to some of this stuff, there's an implicit idea that it's like we're regulating a technology, an it. When in reality, you have frontier model developers, fine tuners, deployers, this whole stack. And right now, we're basically don't know what we're buying if you're downstream. I mean, you have something that's trained by the solution as well as just throw more data at it of not entirely well-defined quality and well-defined scope, and we don't always know what it is. And if I were that person, I would be feeling increasingly uncomfortable with that. And I was thinking that, really focus on what information needs to be passed on meaningfully among the different actors so that you actually they know what they're building on. And that, in fact, I think the federal government could be encouraging standards or disclosures or things here that would actually materially improve the delivery of valuable services here, because as of now, there's no focal points. And I think it's something that studying that we could do that would be consistent with flexibility and not presupposing we have all the answers, and was consistent with sort of the light touch emphasis of the current administration, but would actually, in my mind, give high-powered incentives to solve a lot of these problems without that kind of intervention, and if nothing else, narrow the scope that we need to intervene in, I think, potentially very positive ways.
Okay, we've just got a minute or two left, so I'm going to go around and ask if you have one takeaway you want the audience members or those who are viewing this on YouTube, because we're recording it, to have taken away from this discussion. Jennifer, can I start with you?
Sure. I think that I guess I would lead with it's too early to know what direction we're going. And so I'll probably adopt, even though I'm from the law school, primarily a medical school saying of, right, do no harm. So I think that in these early days of thinking about mass AI legislation and frameworks, that we want to make sure not to lock ourselves in to any particular regime, and to, most importantly, not make things worse. And so I think we need some lodestars. And in the area that I've been spending most of my time in the AI realm with recently, that means making sure we're protecting people's control over their own identities, and that we're protecting the public to best we can without infringing on free speech against deceptive fakes of human beings.
Great. Ioana, 15, 20 seconds.
Jennifer, you said partially what I wanted to say. It's so important to stay flexible in the policies that we are considering, because we don't know yet where it's going to go. And also the market naturally adapts in all sorts of ways that are hard to completely foresee. But when it comes to workers, I do think that we need to think about whether our social safety net is up to task, because it is a general purpose technology, and therefore it will restructure jobs out there, and people will have to change jobs. And therefore, I want us to think about how to design a system that will allow people to find that support as they make that transition, no matter where exactly they end up going. I think very likely they're going to go towards more in-person jobs. But in that sense, we don't want to lock ourselves in supporting a very specific type of transition or a very specific type of training. Again, I think the flexibility is very important, as is the flexibility of income support in general, so that if we need it, we are able to provide additional income support to people.
Thanks, Kevin. Closing thoughts?
The political
Briefly.
ground is shifting faster than people realize. This is a political document designed to get to preemption, but there will be AI safety incidents of various kinds, media reports, and court decisions that I think are going to dramatically shift the political landscape. We're already starting to see that, so pay attention to what happens in the coming months.
And Christopher.
Prepare for the real possibility is that we are witnessing a replay of the dot-com bubble of '99. Is that there's a lot of publications that are saying all this investment, where's the value? And that, in fact, there's a lot of VC money being thrown around very rapidly at an industry that has yet to discover a profitable business model. And so in that world, thinking about it prescriptively may be premature, and that we should be open to multiple futures, including one in which we are going to see, at a time we're worried about big firms, we may actually see a massive shakeout. And that's as equally a possibility, and we have to think about that as a possible scenario we need to plan for as well.
Well, one thing I think is certain in the future is we should have more discussions like this that are probing, informative, illuminating, civil, research informed. That's going to be a path forward to sensible legislation, whatever form it takes. As I mentioned, we have recorded this session. It will be posted on the YouTube channel for the Penn Program on Regulation. If you're not familiar with the program already, you can go to our website, www.pennreg.org, and you can find your way to our YouTube channel from there. With that, I want to thank all of our panel members. I want to thank our audience members and express my regrets to all those audience members whose questions we didn't get to. But this conversation needs to continue. Your questions are important, and the dialogue that we've engaged in is important too. So thank you very much, and have a good rest of your day.